GNLU Centre for Constitutional and Administrative Law. Welcome all of you to this lecture on one of the most significant aspects of democracy, the independence of judiciary. This lecture will be a part of We the People lecture series and will be delivered by Hon'ble Mr. Justice Abhay S, Judge Supreme Court of India. We are truly privileged to have him with us today.
To commence this enlightening session, on an auspicious note, let us now proceed with the lighting of the lamp, a symbol of knowledge and wisdom. I would like to welcome our esteemed dignitaries to join us. May this light guide our discussions and illuminate our minds. Director, Gujarat National Law University, to deliver the welcome address and to set the tone for today's proceedings. Please, sir.
Hon'ble Mr. Justice Abhay S, Judge Supreme Court of India. Hon'ble Mr. Justice Judge High Court of Gujarat. Shri Brijesh Trivedi, President of Gujarat High Court Advocates Association. Professor Dr. Girish, Head of the Centre for Constitutional Law. Dr. Nitin Malay, Registrar of GNLU. All the distinguished faculty members of Gujarat National Law University, distinguished invitees, and my dear students. On behalf of Gujarat National Law University, I deem it a great privilege and honor to extend a very hearty welcome to each one of you to this very, very important lecture series that the Centre for Constitutional Law and Administrative Law organizes as We the People lecture series. And we are extremely grateful to His Lordship Hon'ble Mr. Justice Abhay S, Judge Supreme Court, for having kindly accepted our request and invitation to be here with us today to share his immense knowledge with the students and with the faculty members at Gujarat National Law University. Your Lordship, yesterday I had the pleasure of reading your lecture at delivered as part of the Ashok Desai Memorial Lecture organized by the Bombay Advocates Association. I could, by reading Honorable Justice lecture delivered yesterday as part of Ashok Desai Memorial Lecture, I could only recollect and imagine two honorable judges of the Supreme Court, Justice V.R. Krishna and Justice Bhagwati. I could see both of them in His Lordship Honorable Mr. Justice Abhay S. I am fortunate as a law teacher to have worked closely with both these giants in the legal domain, both with the Justice V.R. Krishna and with the Justice Bhagwati. I could see the same spirit and zeal to ensure justice, and I wish that all of you must read the lecture that was delivered by Hon'ble Mr. Justice Abhay S yesterday as part of the third Ashok Desai Memorial Lecture delivered yesterday at Mumbai. We are extremely fortunate, sir, that today you are here with us to share your immense knowledge and to speak on a very, very important topic that is facing the judiciary today, the contemporary challenges in the independence of judiciary. This is a very important topic at this particular point of time to ensure faith in the judiciary amongst the common man, and therefore, on behalf of Gujarat National Law University and on behalf of the GNLU Centre for Administrative Law and Constitutional Law, I extend a hearty welcome to you, sir, and also to all the distinguished members, including our Justice Ileshwara, sir, who is a member of our Executive Council and General Council, for being present here today. So with these few words, I once again extend a very hearty welcome to each one of you. Thank you so much for joining us.
Thank you, sir, for your inspiring words. Now, I would like to request Professor Dr. S. Director, Gujarat National Law University, to to kindly felicitate my Lord Justice Abhay O, Judge, Supreme Court of India, with a copy of the preamble of the Constitution of India. I would also request Director Sir to kindly felicitate Honorable Justice Alesh Vora with a copy of the preamble and a memento. Girish Sir, our head convener for the Centre for Constitutional and Administrative Law, would like to felicitate Honorable Justice Alesh Vora, Gujarat High Court. Thank you so much, sir. It's an honor to have you. It is with great pride and enthusiasm that I would now like to request Honorable Justice Abhay S, Judge, Supreme Court of India, to kindly unveil our new logo for the Centre for Constitutional and Administrative Law.
The GNLU Centre for Constitutional and Administrative Law stands dedicated to advance legal scholarship and informed dialogue. It is with great pride that we today also unveil the cover for the GNLU Journal for Constitutional and Administrative Law, a biannual journal of the Centre for Constitutional and Administrative Law. This initiative aims to foster research and discourse in the academic field of law, providing a platform for scholars, practitioners, and students to engage in critical discussions and contribute to the ever-evolving landscape of constitutional and administrative law. Our tremendous step towards academic excellence. The GNLU Journal for Constitutional and Administrative Law is a mission as a forum for in-depth analysis and discussions on constitutional and administrative law. We look forward to the first edition and the many insightful contributions it will form.
The independence of judiciary stands as a cornerstone of democracy. The Honorable Supreme Court of India in SP Gupta versus the Union of India emphasized that judges must remain fearless in their duty to uphold the rule of law. This very principle was also reinforced in Supreme Court's Advocate on Record Association versus the Union of India, where the court underlined that an independent judiciary is an indispensable part of a functioning democracy. I am reminded of an insightful incident when Justice Gautam Patel, former judge of the Bombay High Court, asked the distinguished Professor Upendra Bakshi, what three qualities does a citizen expect from a judge at any stage of Indian judiciary? With this characteristic wit, Professor Bakshi simply replied, spine, spine, and spine. Justice Oak too was present at the event, affirming the significance of judicial knowledge and integrity in upholding constitutional values. With that thought in mind, it is my absolute privilege to introduce our esteemed speaker today, Hon'ble Mr. Justice Abhay S Oak, Judge, Supreme Court of India. His Lordship was born on 25th of May 1960 and completed his BSc and LLM from the University of Bombay. He joined the bar in 1983 and after nearly 20 years of practice, was elevated to the bench as the judge of the Bombay High Court in 2003. After serving nearly 16 years at Bombay, his Lordship was appointed as the Chief Justice of the High Court of Karnataka in 2019. During his tenure as a High Court judge, he delivered several landmark rulings on environmental protection and improving living conditions in the cities of Bengaluru and Mumbai. His Lordship was duly elevated as a judge of the Supreme Court of India on 17th August 2021. Notably, just 2 weeks ago, Justice Oak, heading a division bench along with Justice Venkateswar Singh, delivered an important judgment on the necessity of furnishing the grounds of arrest to accused persons. This ruling reaffirms the essence of constitutional safeguards and procedural fairness. Furthermore, Justice Oak has also been entrusted with a significant initiative. He heads the committee constituted by former Chief Justice of India, Dr. D.Y. Chandrachud, for translating Supreme Court judgments into regional languages. This initiative is a landmark step in ensuring greater accessibility to justice for all citizens. Justice Oak's insights and contributions to the field of law continue to shape legal discourse and judicial independence and constitutional governance. Ladies and gentlemen, please join me in welcoming Justice Oak with a round of applause.
Good morning, Brother Justice Vora, Professor Dr. Shanta Kumar, Director of Gujarat National University, Dr. Nitin Malik, Registrar, members of the faculty,
Mr. Trivedi, President of the High Court Bar Association, senior faculty members, and most importantly, young law students. It is always a great pleasure to come to any law school, and more importantly, a national law school, and interact with the students. During last few years, I realized that there is so much to learn from the students. I was associated with National Law School Mumbai. Now I am Chancellor of National Law School at Aurangabad. And right from the beginning, I used to always interact with the young law students. They have their own strong views. They have their own ideas. I experience that every day when I get young students from various national law schools and other law schools as my interns. I always have dialogue with them. They are full of ideas. They have their own concepts, which sometimes I have to correct. I have brilliant law clerks who have taken education from leading law schools in India. Basically, I am here today as a student of law. I can't address you possibly as a judge because as a judge I can speak only in open court and through my judgments. I always tell this to young law students of any national law school. All of you must remember that all these national law schools are set up by spending huge public money. Go to any national law school in India, the national law schools are set up on land given by the government. All the funds for construction of initial infrastructure has come from the government. So it's not like a private law school. It's a law school created by people of the state. And therefore, object of law school cannot be only to create corporate lawyers or lawyers who join firms, lawyers who do only arbitration. The object of any national law school is that it must contribute to the existing legal system. Therefore, object of any national law school must be to create good trial lawyers, good lawyers who appear in High Court and Supreme Court. The object is to create good government lawyers, prosecutors, and more importantly, judicial officers and judges. And not last but not the least, in India, we need quality law teachers. And in India, there is no research in real terms. Whatever research happens is mostly for the purposes of writing thesis for doctorate. So, object of any national law school must be to create top-class lawyers who appear in our traditional courts, top-class government officers, government law officers like prosecutors, advocate generals, government advocates, and more importantly, the judges. The object of national law school cannot be to create only lawyers who belong to elite class. We don't want elite law graduates to pass out of national law schools, because national law schools must give back to the institution, give back to the common man of this country. The law graduates, brilliant minds who will contribute to the existing legal system. Now we have celebrated 75 years of Constitution of India. On this occasion, we the judges, members of the bar, we have been deliberating upon only one aspect: whether the common man of this country has got the quality justice which he expected from the courts under the Constitution of India. The debate is going on this. I have been participating on the debate whether we are able to fulfill expectations of common man. And in this context, the role of young law graduates who come out of national law schools is very important. I strongly feel that some of you or most of you should be contributing to the mainstream justice delivery system. I was associated with some of the law colleges, traditional law colleges, some law schools. Very rarely that we teach in the national law schools or private law schools. Very rarely that we encourage the students to join judiciary. And therefore, today I am taking this opportunity to say something about that. A perception is there that the career in judiciary is not lucrative. I want to clear that perception. Now, after the recent judgment of the Supreme Court, all of you know the judgment in Shetty Commission. A bright young law graduate who has not practiced before court of law can enter judiciary. And today, when such a young lawyer at the age of 26, 27 enters judiciary, his take-home pay is something like 94,000, 95,000 after deducting income tax. Then he gets free accommodation, all category allowances, including driver's allowance, at the age of 25 or 26. And look at the civil services or IAS or IPS, those who join the government service as IAS or IPS officers, their starting pay is somewhere between 75,000 to 80,000. Of course, I do see a change. Few years back, I visited Bihar Judicial Academy. I addressed about 300 newly appointed civil judges. I found that there were about 23 or 24 of them. They are all graduates of national law schools. So, when you think about your career, please do think about career in judiciary. There is a vast difference between career as a lawyer and career in judiciary. When you are a lawyer, you may be really good, but your performance as a lawyer is controlled by several factors. You are answerable to your client. You may have a very tough opponent. You may have a court which is very strict. Or to say very candidly, you may face hostile judge. So your performance is circumscribed by so many factors. But when you are a judge, nobody can control your performance. All that you are required to do is follow the law, follow your conscience, and follow the principles laid down in the Constitution. No power on the earth can control what you are going to do as a judge. So it's a beautiful and satisfying job. I have been a lawyer for 20 years and a judge for 21.5 years. And I can tell you from my own personal experience, the work satisfaction which you get as a judge can't be compared with work satisfaction you get as a lawyer. So therefore, my appeal to young students is please contribute to our traditional legal system, because we need to deliver quality justice to citizens of India. Now, after all courts after 26th of January 1950 exist under our Constitution, and therefore common man is right in expecting that you will get quality justice, you will get expeditious justice. So that is the first part which I wanted to tell you. All of you know that independence of judiciary is part of the basic structure of the Constitution. I need not dwell upon all the judgments starting from Keshavananda Bharati. Because only if there is independence of judiciary, the judges will be able to deliver quality justice. This is one subject on which I can go on and on. But there are two restrictions on that. One is, today I am holding post of a judge of the Supreme Court of India. So therefore, I have to follow certain constraints. Maybe even after I debut office, I will be slightly more free, but then also I have to observe constraints. But still, I am going to look back into history and tell you something about the independence of judiciary. I firmly believe that the judges themselves have responsibility to ensure that the judiciary remains fiercely independent. Because we ultimately take an oath under the Constitution. Even civil judges take oath when they are appointed. We take oath to uphold the constitutional law. We take oath to deliver justice without fear or favor. Therefore, essentially, it is the responsibility of the judiciary to maintain fierce judicial independence. But at the same time, I always believe that it is the responsibility of the members of the bar to ensure that independence of the judiciary is maintained. And that responsibility is not confined to the members of the bar. If our society, if our citizens want fiercely independent judiciary, then it is a duty of every common man, every educated person, every right-thinking person to stand by judiciary when there are attempts of encroaching upon the judicial independence. I always believe, as a judge, that we are answerable to common man, and therefore I have said on public platform, your Vice Chancellor referred to the lecture delivered by me yesterday. On every time I address the students or lawyers, I have said this, that every citizen of India has right to criticize the judgments delivered by the courts. But that criticism has to be constructive criticism. Somebody can't get up and say that a judgment of the court is wrong. I don't agree with the judgment. That can be said by anybody. But if you want to criticize the judgment, you must criticize it by saying that these are the grounds on which the judge has gone wrong. Or this is the finding which is recorded by the judge is contrary to the well-settled and well-established law. So it has to be a steady criticism. It cannot be that Supreme Court pronounces a judgment morning at 10:30 and by 6 o'clock so-called experts are ready to debate on the judgment. The judgment is right or wrong. When you want to criticize the judgment, you have right to do so. But please examine the judgment. Please examine the judgment carefully and then say why the judgment has gone wrong. And it is all the more responsibility of young students that you must develop that analytical mind. Now today we have released a journal. In this journal you can write articles that here is a judgment of the Supreme Court or High Court or for that matter trial court, and this judgment is legally wrong. You must record reasons. And one more constraint you must always remember. When you criticize the judges, you criticize the judiciary, we follow a self-constraint or self-restraint. We never respond to the criticism offered to our judgments, our actions. Because we don't belong to political class that we can go back to the media and say that the criticism is not correct. We are not supposed to do that. We are holding constitutional posts. For that matter, the judges of the trial court and district court, now after the constitution came into force, they are all constitutional courts. The service conditions and other things are provided for the district and civil judges are provided in the constitution. So therefore, while upholding the right of common man to criticize the judgments, I always tell, and especially the law students, that it has to be done with a great deal of responsibility. In fact, time and again, the judiciary itself has acknowledged the mistakes committed in the past. When the judges felt that something wrong has been done, the judges themselves have responded and taken corrective action. One such example from the history which I want to tell you. In 1908, a very famous patriot, a great thinker, and somebody who championed freedom of speech and expression, editor of one of the leading newspapers in Pune, Kesari, Lokmanya Bal Gangadhar Tilak, was tried for sedition. Since all of you are lovers of Constitution, I will request you to read the defense speech by Lokmanya Tilak, because he himself addressed the jury. He had support a battery of great legal minds, but he chose to address himself. In those days, it was a jury trial before Justice Dawar. And that speech which he has delivered is very relevant today. When we talk about offense of sedition, even today in 2025, that speech is brilliant. In fact, he begins his defense speech by telling everybody that he owes full responsibility for what he had mentioned in the article, what he had written. He says that I take full responsibility, very consciously I have written this article and criticized the government. And then he goes on to explain to the members of the jury what is the concept of freedom of speech and expression in the context of freedom of media, freedom of press, the entire emphasis on freedom of press. And there is one beautiful sentence where he says that I know British government does not like me at all, but that does not mean that British government should prosecute me for sedition. So ultimately that trial ended in conviction. He was sentenced to suffer transportation for 6 years, and all of you know that he was sent to jail in Mandale. And British government was so harsh that when he lost his wife, he was not even granted parole or any other relief or temporary bail. Something important happened when Chief Justice M.C. Chagla, after independence, he was the first Indian Chief Justice of Bombay High Court. In 1956, he held a function in historic courtroom number 46 of the Bombay High Court, where actually the trial was conducted. And if you go to room number 46, outside room number 46, the great words of Lokmanya Gandhinagar were inscribed. Those words he uttered when Justice Dawar pronounced that he is guilty. And he asked, Mr. Tilak, do you want to say anything? Then he says those famous words that in spite of verdict of judiciary, verdict of the jury, I maintain that I am innocent, and there are higher powers which rule the destiny of men and nations, and it may be the will of providence that the cause which I represent may prosper more by my suffering than by my remaining free. So he said, yes, I'll accept the verdict, because I know that the cause which I represent will prosper if I undergo imprisonment for 6 years. What Chagla did was something different. He openly apologized to the members of the bar and who were present there, and he said that it was a mistake committed by Bombay High Court, namely Justice Dawar, in convicting a great patriot like Lokmanya Gandhinagar. So he accepted openly the mistake committed by his predecessor. Of course, that action of Justice Chagla was also criticized by some members of the bar, some renowned journalists. Their view was that what Justice Dawar did was completely in terms of the law prevailing at that time. So whatever was the law applicable, he followed that law to the letter and spirit. And therefore now, after years, you can't blame Justice Dawar. Now whether Justice Chagla was right or wrong, that's a different thing. And since what Justice Chagla said openly, he did not say it as a judge, therefore rightly people criticized him. There were not many who supported him. But the fact remains that a Chief Justice of Historic High Court of Bombay publicly apologized for what was done by one of the judges. And I can tell you several instances. For example, you must have studied that judgment of the Supreme Court, ADM Jabalpur versus Shivakant Shukla, that rendered in days of emergency. Later on, Supreme Court overruled that judgment. So there are a number of instances where the judiciary itself has accepted that earlier judgment was wrong, we have corrected our own verdicts. How independence of judiciary can be affected? There are historical examples. Because there are constraints on me while addressing you on this subject, and maybe after 4 or 5 months, I may be in better position to address you on this subject. Now, first and foremost is great judgment in the case of Keshavananda Bharti. You know what is the citation of your judgment? You must have read it, 1973 for SCC 225, where Supreme Court by majority upheld the basic structure doctrine. And as a student of law, again as a student of law, I must say very candidly that this is one judgment which has saved the independence of judiciary and democracy in India. Look at what happened on left-hand side of India and right-hand side of India. The constitutions have come and gone, but India has remained united. Now credit has to be given to our constitution, the vision of Dr. Baba Sahib Ambedkar, other framers of the constitution, and more importantly, to one decision of the Supreme Court, which propagated basic structure doctrine. But what followed thereafter is very important. Till that time, consistent tradition was followed that the senior most Supreme Court judge will be appointed as the Chief Justice of India. And I think on 26th of April 1973, the then government took a decision to supersede Justice Shelat, who was in line to become Chief Justice of India. Incidentally, Justice Shelat was someone who was practicing in Mumbai. Then he shifted to Gujarat after bifurcation of state, and he became judge of the Judicial Court. Not only Justice Shelat was superseded, but two other judges, Justice Hegde and Justice Grover, who were in line after Justice Shelat, they were superseded, and Justice Ray was appointed as Chief Justice. I read an autobiography by Justice M.C. Chagla. By that time, he had become the President of the Supreme Court Bar Association. The Supreme Court Bar Association met in the morning and took very extraordinary step of condemning the government in no uncertain terms. And I am told that in protest they did not participate in the hearings of the court on that day. Of course, in retrospect, I must say that now the law is very clear. Bar members have no right to boycott the court proceedings, because when one day boycott the court proceedings, thousands of litigants are affected. Now, the law of the land is that such protest in the form of boycotting the court is criminal contempt. But the point is, at that time, bar stood firm and they protested about supersession. Then second supersession happened after the decision in the case of ADM Jabalpur versus Shivakant Shukla in 1976 to SCC 521, where the argument of the government and the Attorney General of India was that since due to emergency declared in 1975, June 1975, the fundamental rights have been suspended. Therefore, if a person is illegally arrested by the police, he has no remedy before the court. That was the argument. And that argument was accepted by the Supreme Court by a majority of 4 versus 1. And who was the great judge who dissented? He was Justice H.R. Khanna. I request all of you to read his autobiography, Neither Roses Nor Thorns, where he has said that after he wrote Dissenting Lu, he went to Haridwar and was sitting with his wife overlooking river Ganges, and he told his wife, yesterday I had written an opinion which may cost me the post of Chief Justice of India. And that indeed happened. He was superseded. That's the history. At that time also members of the bar protested, but not the way they should have done it. Of course, there are 2 prior attempts. I am told, I read it in the history. One was when Justice M.C. Mahajan was stated to become Chief Justice. He was the senior most judge in Supreme Court. A highest functionary of the government told Justice B.K. Mukherjee, who was next senior to Justice M.C. Mahajan, that there is a proposal to supersede Justice Mahajan and to appoint Justice Mukherjee, B.K. Mukherjee, as the Chief Justice of India. The response of Justice Mukherjee was, if that happens, he will step down and resign. And I am told other judges of the Supreme Court responded. And therefore, supersession was saved. Same thing I read about one attempt before Justice Shelat was, after Justice Shelat was superseded and before Justice Khanna was superseded, there was a move to supersede Justice J.C. Shah, who became Chief Justice of India. At that time also, I think next senior most judge, Justice Hidayatullah, protested. He said that if Justice Shah is superseded, he is appointed as the Chief Justice, he will quit his post as a Supreme Court judge. You know, this is a glorious, I am not saying that the supersession is glorious history. Supersession was very bad. Supersession was something which should never have happened. Supersession affected the independence of judiciary very badly. But there is a saga of stories of all these great judges who protested in their own way. Imagine a judge told by highest functionary in the government that you will become Chief Justice, not somebody who is senior to you. The person telling the highest functionary, look, if that happens, I will step down. What kind of sacrifice these people, great judges, made to protect the independence of judiciary. And I must tell you, there are instances where the members of the bar have stood for independence of the judiciary. As I have constraints, I am only talking about historical events. Then one such historical event to which I was a witness as a young member of the bar, that happened in 1989-90, when two prominent bar associations, the first one was Advocates Association of Western India, which is the oldest bar association in the country. Jurisdiction of Bombay High Court once extended to Sindh, which is now in Pakistan. So Western India Advocates Association extended its jurisdiction to Sindh. Gujarat was included in that. So the president and senior members of bar took extraordinary step by passing a resolution expressing doubt about integrity of 4 judges, sitting judges of the Bombay High Court. And it was followed by a resolution passed by another strong bar association, Bombay Bar Association, which is again historical bar association, which represents the original side bar of the Bombay High Court. Now, both the bar associations passed a resolution expressing concern about integrity of 4 sitting judges, which led to transfer of 2 of them. The then Chief Justice of Bombay High Court, Justice Mukherjee, thought it fit not to assign work to other 2 judges in their retirement. So Chief Justice Mukherjee was also, Chittotosh Mukherjee, one of the greatest judges I have seen as a member of the bar, he also stood firmly for independence of the judiciary. Then there was a resolution passed in 1995 by Bombay Bar Association expressing concern, a deep concern about the then Chief Justice of Bombay High Court, which ultimately led to the resignation of the Chief Justice of Bombay High Court. So these are the glorious traditions. In 2017, on the application made by the government through Advocate General, very sensitive litigation was withdrawn from one particular division bench of the Bombay High Court. Within 36 hours of that event, both the bar associations responded. They passed very strong resolutions condemning the government, the Chief Justice, the Advocate General, etc. And then the Chief Justice had to reverse the administrative order. So there are instances and instances where since I come from Bombay, I am telling you instances what happened in Bombay. But the positive initiatives taken by the bar to maintain the freedom of the independence of judiciary are not confined necessarily to Bombay. There are several such examples happening in other states also. So, as I said, independence of the judiciary is basic structure of the constitution, and this basic structure has to be fiercely protected. And as I said, the judges must do it, but more responsibility is on the members of the bar, because ultimately members of the bar have that freedom to say something which judges can't say, to do something which judges can't do. And that's why you, the young students who are doing work for the Constitution of India, you must remember that this is going to be the huge responsibility on your shoulders. And there are several other things which are there. Now, there's the issue of some kind of a media trial. Of course, media trial has become very, very now a small part. Now, I should say the social media trial. Young students, I want to tell you something about this social media. I also agree that this social media helps the creativity of the students. Otherwise, earlier it was very difficult. Somebody is writing a poem, somebody wants to write an article, somebody wants to write a story. Young students I am talking about. He can do so by accessing to social media. But when it comes to judiciary, you have to be a bit discreet in the sense that if somebody writes something erratic or something scandalous about the judiciary. Before advent of social media, all this was discussed within 4 walls, inside the 4 walls. But now with social media, some scandalous material appears and routinely we forward it to several people. And you know, if one lie is repeatedly told to people, some people start believing that it is true. So therefore, my appeal to young members of the young students is to use social media discreetly and constructively. It is one of the best weapons available. You can share knowledge. I share a WhatsApp group with my young law clerks. I mean, they share good articles written not only about law, not only about judiciary, but good articles written on environment, good articles written on literature. So the social media can be used very, very constructively. But when you are a student of law, when you become a lawyer, please observe some restraint. If you get an article criticizing judiciary, please verify whether what is stated in the article is correct and thereafter forward it. I always believe that fiercely independent bar is the only answer to any attempt to make any interference with the independence of judiciary. So it's the bar which plays the key role in maintaining the independence of judiciary. There are several instances where the freedom of judiciary is tried to be curtailed. They are in the form of judgments. For example, in NJSC judgment, the power of the collegium was sought to be taken away, and there was a judgment striking down a law framed by the legislature. So there are instances and instances where the judiciary itself has taken a proactive action, as I said, by correcting its own earlier views and by taking affirmative action of striking down legislations. I can tell you several such examples. Some of the states in 2005 decided to apply a new pension scheme to the judicial officers. The result of application of new scheme was that 10% of the salary of the judges would have been deducted towards the pension. Many High Court steps in. The High Court said that service conditions of the members of the judiciary are controlled by first is Shetty Commission judgment, then Padmanabhan Commission judgment, and therefore you can't tinker with the service conditions of the judiciary. And the applicability of the pension scheme was struck down. So there are instances and instances which I can give. Before I close, only two or three things which I want to share with you. When I come to any law school, my mind goes back to 1980, when I was student of Government Law College in Mumbai, which is the oldest law college, which has given such a great talent to Indian judiciary and Indian bar. But education in law was different. In fact, by 1980s, it was believed that those students who cannot secure admission to engineering or medical or other professional courses, as a last resort, they used to join law colleges. I must say that trend changed successfully when the Bar Council ultimately permitted 5 years course to be conducted. So those were the days where 3 years LLB course was a part-time course. We used to have 2 lectures per day, 2 lectures, please remember one thing. Then we did not have those moot court competitions, whereas there was only one moot court competition every year. There were no other mock trial competitions and no other competitions were there. We were confined to hearing those 2 or 3 lectures per day. And of course, since it was Bombay, we had other advantages. Bombay High Court was very close by. So afternoon we could just go to Bombay High Court and hear great lawyers in action. Of course, in those days, very little we could understand when complicated issues were addressed before the Bombay High Court. Then there was a beautiful British Council library. I'm talking about 1980, which used to show beautiful video films. And then there was a Wankhede Stadium, very close to the Government Law College, where we could buy ticket by spending ₹1 and see Gavaskar, Vishwanath, and so many great cricket players in action. But the quality of law education has substantially increased. And therefore, I always tell young students of law colleges and law schools that you belong to a very privileged generation of law students, where you have full-time education in law. You have such a beautiful campus like this university. You have opportunity to interact with great legal minds, great academicians, great professors. You get interaction. You can interact with the sitting judges of the High Court. You are fortunately with all national law schools, the Chief Justice, local Chief Justice, the judges, they are associated. So you have opportunity to interact with the judges of the High Court. So from 1990 onwards, the quality of legal education has improved, and therefore you belong to a privileged generation of students. So take full advantage of this. When I was a student, I would not have imagined such lecture being held by calling a sitting Supreme Court judge where students will get opportunity to interact with him. So take full opportunity of these great facilities available for legal education. And some time back I talked about joining traditional legal profession. I must tell you that now legal profession is the most lucrative profession in India. If you compare it with the profession of doctors, chartered accountants and other professions, it's the most lucrative legal profession. And mind you, it is the most challenging legal profession. So, please remember my advice. I am not advising you as sitting judge of the High Court or Supreme Court. My advice to you as a student of law, my advice to you as somebody who is part of the legal system for the last 43 years or more. And therefore, please take advantage of all beautiful and great facilities you have here. And ultimately, after you pass out, please contribute to the Indian legal system. That's my appeal to you. And lastly, but not the least, please ensure that we have fiercely independent judiciary. Thank you.
Thank you so much, sir, for sharing your invaluable perspective. We are indeed truly enlightened by your words of wisdom. Your insights not only shed light on the evolving legal landscape, but also serve as a guiding force for aspiring legal minds and practitioners alike. We all are truly grateful for your time and presence today, and we look forward to carrying the lessons imparted through your address. We would now like to open the floor for questions. Due to the paucity of time, we'll be only able to entertain 2 to 3 questions. Those of you who have any questions, kindly raise your hand so that our volunteers can get you the mic. Yes, sir.
Good morning, sir. Sir, I wanted to know that as a judge, what is the most difficult...
Can you please stand up? Introduce yourself.
Good morning, sir. My name is Tanish. Sir, I want to know that as a judge, what is the most difficult decision you have made until now?
See, I'll tell you, to put it straight, barring routine matters, every decision is a difficult decision. But if you ask me that question, I can name several decisions, but one decision I can name is where in Bombay High Court, there was a petition filed for challenging law prohibiting slaughter of cows and progeny of cows. And that was one case which was not heard by many benches, many judges recused. And the hearing went on for 3 months. And deciding that case was very challenging because that was first case where High Court we had to hold that right to privacy is integral part of Article 21 and Puttaswamy judgment was there. But I must tell you very candidly, there are hundreds of cases which we find very tough to decide. And every case is challenging. I'll give an example. Suppose we are dealing with a case of a matrimonial dispute. We are always conscious in the back of our mind that one matrimonial dispute affects 3 families. One is the family of husband and wife, one is the family of the parents of the husband, other is family of parents of the wife. So such decisions do take long time because we deal with life of human beings. Same is the case with appeals against conviction or appeals against acquittal. It's not a simple case that somebody challenging order of conviction before us. We have to apply our mind and decide whether there is evidence which is sufficient to prove his guilt. But at the same time, we have to also keep it in mind the plight of the victim of the offense or the concerns of the society. So, in constitutional court, I can assure you, barring few cases, every case is challenging, very difficult to decide.
Thank you, sir.
Yes, go ahead with your question.
Hello sir, this is Aditya from first year. I wanted to ask, as we are discussing on independence of judiciary, whether the lack of proper infrastructure in district judiciary affects the independence of judiciary. Secondly, you are asked about joining young student joining lower court. So why should we not proceed towards unified judicial services under the able guidance of the Hon'ble Supreme Court?
Firstly, I want to correct you. Please don't describe any court as a lower court. See, no court is lower court. If you see provisions of the Constitution, even our district courts and trial courts are given status of constitutional courts. As a Chief Justice in Karnataka High Court, the first administrative order which I passed was that in our district judiciary or in correspondence entered into by the High Court, no court should be described as lower court or subordinate court. I personally believe that describing any court as lower or subordinate court is against the ethos and ideals of our Constitution. And mind you, when you talk about civil judges and district judges, I have said repeatedly on public platforms that these are the courts of common man. Common man get justice there. Secondly, yes, of course, the judiciary must have proper infrastructure. In fact, you can see my judgments. There was a special bench constituted by the then Chief Justice Mohit Shah, which was always headed by me for 3 to 4 years, when we had to deliver large number of judgments directing government to release money for construction of judicial complexes. But so therefore, proper infrastructure has to be there. There is no doubt about it. And about the unified judiciary, this requires a lot of debate. The reason is, on one hand, now there is emphasis. See, as I told you, the civil courts and district courts are courts of common man. And therefore, now in all states, the emphasis is on conducting the court proceedings in the local language which common man understands. The emphasis is on delivering judgments in the language of the state. And therefore, in continuation of that, now in Supreme Court, we have translated 36,000 judgments of the Supreme Court in Hindi. And all high courts are translating their own judgments into local languages. Like the unified judiciary at the level of civil court, there will be grave difficulties because now if you want to work as a judge in Gujarat, you have to be proficient in Gujarati language. The reason is that you will be recording evidence in civil and criminal cases. Unless you are conversant with the language of the witness, you won't be able to record it efficiently. Because recording of evidence, especially in criminal cases, has to be flawless. Because no higher court can correct that. So that's a grave difficulty in floating the idea of some kind of one judiciary for the state. Of course, there are other things, that there can be unified standards, there can be common entrance examination. But those who appear from Gujarat, they will be ultimately assigned to Gujarat judiciary. So that thought process is going on, but it will take some time.
Thank you, sir.
Thank you, sir. Sir, go ahead.
Good morning, my name is Swayam Shah and my question is, the decisions of the Honorable Supreme Court affect India. So as a judge of the Supreme Court, what according to you is India?
See, as far as India is concerned, I don't think it should be a matter of debate. What is defined is told to us by the Constitution itself. In fact, our preamble begins with that. Ultimately, you talk about a country. When you talk about a country, necessarily you must talk about the citizens of the country. And please remember one thing, when we are sitting in the Supreme Court, we are not concerned only with the citizens of the country. There are articles under the Constitution like Article 21, 22, they confer fundamental rights on every person irrespective of citizenship. So therefore, necessarily when you talk about India, we talk about citizens of India. And India is such a diverse country that people who stay in a particular area, they have their own issues, they have their own culture. So therefore, when we deal with the cases, we essentially deal with the cases of human beings, those who are citizens of India, those persons who are residents of India. So therefore, we don't go by the geographical idea of India. There is something more into that.
Thank you, sir. The gentleman in the yellow kurta.
Good morning, Honorable Justice. My name is Keshav Bansal. I am a fifth year law student at Gujarat National Law University. So, in one of our constitutional law classes, an observation was made that historically speaking, the judiciary gets weak when the government gets strong, and the judiciary gets strong when the government was weak. What are your thoughts on the statement in the context of the contemporary challenges that the judiciary faces?
Perhaps what you are telling me is the quote by Professor Upendra Bakshi in Indian Supreme Court and Politics, if I recollect correctly. See, I always believe in one thing. Now, I am part of the judiciary for the last 21.5 years. Now, if judgment is to be delivered on how the courts have functioned, that is a prerogative of the members of the bar and citizens of India. So, therefore, this is a criticism of judiciary. And therefore, I would not like to respond, because I don't want to disrespect the views expressed by Professor Upendra Bakshi. He is such a great jurist and great thinker. But I will put it this way, this is one of the perspectives with which you look at the judiciary. And if somebody wants to say that, I will not have quarrel with it. Because ultimately, we as judges, when such criticism offered by a visionary in law, we always take such criticism constructively. We introspect and try to find out whether what Professor Upendra Bakshi has said is right. And in some respects, if we find that some criticism is right, we always try to introspect and improvise.
Thank you so much. So, one question on the litigation aspect.
We have many other people who want to ask questions. Thank you so much. We'll get some female representation. If we can get some mic, we can get a mic here. Fine. You followed by her.
Namaste, sir. I'm Gauri. I am in the first year. And my question was that you emphasized about how the courts that function at the district level are constitutional in nature. And why is it then that the prefix justice is not used for judicial officers who work in the in the courts that function at the district level?
I'll answer that question. Before I answer that question, now I must have gone to several national law schools and traditional law colleges. I prefer to go traditional law colleges in district places also. When this such question and answer session is there, the majority of questions comes from girls. But today I find exception. And one more encouraging thing which I want to tell. During last 10 years, when we have recruitment of the civil judges, now in every state, barring few states, which are in the hilly area, now 50 to 60% of the newly appointed judges are women judges. So at least, though late, at least I saw some girl asking me very interesting question to which I may not have correct answer. Yes, you are right. I mean, in independent India, why somebody should be described as justice. You are right. Whenever occasion arises, we avoid using that. In fact, you come to my residence in Tughlaq Road, my name is there, but I have not said Justice Abhay. It is only Abhay. Yes, you are right. I mean, we need to correct that. As I said that I have to correct the use of words like lower court, subordinate court. Slowly we have to correct that also. Because that way we sit in constitutional courts, the civil judges and district courts sit in the district and trial judiciary. I mean, the work done is the same. Maybe we have more powers under Article 226, 227 of Supreme Court 140. But someday this distinction will have to be done away with. But you know, good changes do take time in our system.
Thank you, sir.
Thank you, sir. The ma'am here. Can we get the mic here, please? Thank you.
Very good morning, sir. My name is Siddhi and I'm from the third year. Sir mentioned that this is probably the prime of legal education and this age right now, and the legal system in general. However, lack of access to justice still remains a very huge issue. So on these lines, I have two questions. Firstly, what do you think are the prime reasons for this? And secondly, what are some immediately actionable steps that law students can take which can probably help in improving this issue?
See, this is actually accepted thing that even today, after 77 years of independence, there are large sections of our society who, by reason of social or economic backwardness or various other reasons, they are unable to access to justice and they suffer injustice silently. And that's true. Nobody can deny that because so many eminent judges have said that explosion of dockets is an issue, but exclusion of dockets is also an issue before us. The answer to your question is, please participate in the activities of the legal services authorities. If you become paralegal volunteers, you can do great work. You can go to prisons, you can go to villages, find out whether anybody is suffering injustice silently. I'll give you one example, how the law students can do wonder. In Maharashtra, in one of the districts, there was a nuclear power plant set up. And therefore, 2 villages were required to be shifted. The idea of the government was very good. I mean, they decided to recreate those villages somewhere else with the same name, same revenue villages with the same name. Then houses were provided, infrastructural facilities were provided. Some organizations filed a PIL. And that PIL, High Court was monitoring it continuous mandamus. So one of the Chief Justices passed an order that High Court Legal Services Committee, which deals with legal aid to the litigants in the High Court, the Legal Aid Services Committee headed by the chairman should go to the grassroots, hold meetings, find out what is happening. So when I became chairman, I started holding meetings. I used to call Secretary of the Atomic Energy Department, revenue officers of the government. I had gone to those villages personally. I could see that infrastructure was only on paper. There were houses, but elementary facilities were not there. Regular water supply, electricity supply, facilities of education to the children, medical facilities, they are all lacking. After holding so many meetings, somehow I thought that I am not making any progress. I was associated as member of the Executive Council of GNLU Mumbai. So I told my Vice Chancellor that select young law students, constitute a team, then we prepared a questionnaire. So we took those students in buses to that village for continuously 2 days and we left it to the students. Questionnaire was only for their guidance. I told them, you prepare your own data, give your own impressions. The students went there and within few days they came out with a PowerPoint presentation. I called a meeting of their additional solicitor general was there, secretary of the Atomic Energy Department, and we showed that PowerPoint presentation on the screen. I had held about half a dozen meetings which were not effective. I personally felt that. But that PowerPoint presentation completely changed the views. The additional solicitor general was present. He said, sir, now this is an eye-opener for us. So now you leave it to me, I will hold meetings of all the stakeholders. Very effective way. Second and last example I will give you. There was some function of legal service authority in Pune. While I was traveling, I received a phone call from my mobile of some woman, I don't know, who shared my cell phone number. She was not a poor woman, but she was staying alone. She had no children, she had lost husband, but she had financially, she was quite sound. Due to some ailment, her one arm was amputated. So she went, this was 2017-18, I used to see in newspapers that unless you have Aadhaar card and link Aadhaar card to your bank account, you won't be able to operate bank account. She went to one Aadhaar center sitting on a wheelchair. One of the legs were also paralyzed with some help. They told her that, we need impressions of all 10 fingers. So she was very disturbed. She said that you talk about justice, access to justice, what I am going to do? If I can't have Aadhaar card, I won't be able to access to my bank account. So I talked to one of the professors in the city law college. The professor deputed perhaps some young law students. I don't know what they did. I think they must have gone and they must be after those officers of that department. Within 3 or 4 days, some officers of the department went with all those machines to the residence of this lady, and within 7 days, Aadhaar card he got at her doorsteps. So, if you become paralegal volunteers, you keep your eyes and ears open, you can do wonders. Every single paralegal volunteer can improve the access to justice.
That was very insightful. Thank you.
Thank you, sir. We'll be taking two more questions. Shubh.
Good morning, Your Lordship. My name is Shubh Nayak and I'm from the 4th year in GNLU. Your Lordships, we at NLUs have this habit of being fascinated by Supreme Court and High Courts that we often tend to miss out on discussions about civil judges and district judges. But the civil judges and district judges, because they are newly recruits, are faced with a lot of fear and a lot of incentive issues. For instance, which affects their decision making. For instance, the Honorable Supreme Court almost across all the days is flooded with a lot of bail applications across different benches. So, Lordship, how can we regulate the independence of judiciary and the civil judges to ensure that the fear and the bureaucratic pressure over the newly recruits is done away with and they do not have to face this issue which leads to overburdening of cases at Supreme Court?
See, this is a very wider issue. Per se, I will not say that this is happening because our district judges or session judges, they are under some kind of a pressure. There are reasons and reasons. We appoint a new law graduate as a civil judge. It takes time for the newly appointed civil judge, though we give training in our judicial academy. There are good facilities of training. It takes time. It takes time for the newly appointed judge to get acquainted with nuances of law. See, for judges, every day it's a learning experience. If I go to Supreme Court, I have to decide the cases dealing with laws which I have never dealt with. Maybe after 15 or 17 years as a judge in the High Court. So it takes time for judges to learn. There are various aspects of it. Per se, I won't agree that because there is some kind of pressure, therefore bail is denied. It may be the mindset, it may be the course correction approach is required. And I don't think it's a universal rule. I read in Times of India, some judicial officer in Pune has passed a very strong order granting bail in a case where the allegation was under the POCSO. Some changes are required, you are right, and those changes may happen because there is very intensive training which we give to the judicial officers. And see why this happens, I tell you. As the Chief Justice of Gandhinagar, in 2020, we conducted two processes for appointing civil judges. Though we conducted two processes in a pandemic, we could not get sufficient number of candidates to fill in those posts. So, one way of looking at it is that why members of the bar are lagging behind? Why young and bright minds or young and bright law graduates are not thinking about joining judiciary? So, it's a vicious circle. I remember as a young lawyer, I attended one workshop in Pune where one of the very eminent retired judges addressed the gathering. Same issue was raised. So his answer, which I do not say that is fully correct, but what he answered was that sometimes, quality of the bar is also reflected in quality of judiciary. Because ultimately, bar, as quality lawyers and quality lawyers enter judiciary, that will be reflected in judiciary also. So it's a vicious circle, it's a process, which needs application of mind. We need to encourage more and more bright minds to enter the judiciary. And that's the process, which will be an ongoing process. But you are right, there are some concerns which are being addressed.
Thank you so much, sir.
Thank you, sir. First we'll go to Harsha ma'am and then finally we'll come to sir. Yes, Harsha ma'am.
Good morning, sir. Thank you so much. So at Gujarat National University, sir, we have a unique initiative which is GNLU Wellness Initiative Cell, where we work with the students for the mental health and the emotional well-being of the students. And at many intervals, sir, we have contemplated this issue of mental health and emotional well-being in the judiciary and the judicial environment in particular, sir. So do you think, sir, with your experience, having a career in bar and as well as a career as a judge, do you think that contemporary
challenges do affect the emotional well-being or pressures, wherever it comes from, do affect the emotional well-being and the mental well-being, which has a clear correlation with respect to the quality of justice. And when you speak about value-oriented approach towards independence of a judiciary, don't you think there is a requirement to have a strength to uphold these values towards the judicial independence? Sir, if you can reflect on it, and if you feel that this is something very relevant, sir, we'll be very happy to work with you in terms of this area and research.
One thing, part of it may be correct in the sense that now in our judicial academies, we call experts in the field. There are very eminent psychiatrists in Mumbai who has done a lot of work in this area about the psychological well-being of lawyers and judges. Now that gentleman is a regular visitor to National Judicial Academy. He is a regular visitor to Judicial Academy in Maharashtra and of course some other judicial academies. Personally, I don't think that these pressures affect the psychology, because I believe that if you are a judge, you should be so strong, mentally strong, that you should be able to withstand all the pressures. In our trial judiciaries, of course, there are some concerns because the judicial officers are young. They are subjected to transfers after 3 years, and that causes strain. And their judicial academies are already taking the help of experts in the field, because it's not easy to get uprooted after 3 years, especially when you are young children, you are family. And there are so many issues which we addressed. One issue was, now I said, 60% of the newly appointed judges are women, and naturally they are in the age group of say 26 to 30 to 33. Talking about Maharashtra, we have to amend our ways. What we said was that those judicial officers who are small children will allow either the mother or mother-in-law of the judicial officer to stay with her in the academy, so that the judicial officer without any stress can concentrate on the training given. And I can say that I can always say that some help will be required, but I personally feel that judges should have such a strong mind that they should not require this help, but at the same time, few areas are there, as brother rightly put. There is a transfer policy in place. Now we have very unique thing which is happening in judiciary. There are a large number of married couples, both husband and wife are judges. So almost all states have a policy that both husband and wife will be posted at the same station or at nearby place to avoid stress. But there is always difficulty about work-life balance. For example, I tell you, holidays, vacation of judges is one issue, but if you know some of the judges in our trial judiciary, as in Maharashtra, I think here also judiciary has holiday on every Sunday and I think second and fourth Saturdays. I can assure you that every judicial officer spends at least 3 weekly holidays in either attending to legal service authority functions, some legal literacy seminar, workshops for training. So if you have say 4 plus 2, 6 weekly offs, 50%, minimum 50% of those weekly offs, the judges are in either court or some place where they look at there is some legal literacy camp. And that disturbs the work-life balance, where he has family to look after, children at home, responsibility of the parents. But this is one area which is not known to many. That, see, judging is not only sitting in the court and deciding the cases. Judging is something more. Every judge has to participate in functions of the legal service authority. The judges of the High Court have administrative duties to perform. There are administrative meetings. So that creates a stress. And there, we have no hesitation in taking the help. I mean, you are working in right direction. And in fact, from my experience as somebody who associated in national law schools, a lot of students need this now, because they are very intelligent, very ambitious, and they are fiercely competitive, and therefore they need this help. But judiciary also, without hesitation, we are taking care of that.
Thank you so much.
Good morning, sir. My name is Vikram Shroff. I am the employment law partner at ACB, and just like you, I also studied at GLC. My question is about comparing India with developed countries like US, UK. Our judgments, especially at High Court and Supreme Court, the quality of judgments are similar or even better than some of the developed countries. The way over the last 10-15 years. The difference I see is in terms of the court submissions, the pleadings and the case papers. I think India remains a very complex jurisdiction, and there is a mindset that the bigger and lengthier the petition, the better it is. Whereas when you see the filings in some of those countries, it is very simple, to the point, very basic, and you can understand as a reader in a few minutes what really is the case. So I just wanted your analysis as a judge when you get all of these detailed submissions and filings, evidences. How do you react? Like, what is your message to the parties?
I think you have showed restraint. Perhaps you wanted to say about very lengthy judgment delivered by our courts also. You cannot say that. I can appreciate that. See, I have said that in one of my judgments under the Arbitration Act, that arbitration in India has become synonymous with bulky pleadings, bulky arguments. This is because legal profession has become most lucrative profession, and the lawyers want to argue more. Somehow we are not able to restrict the arguments. Individually, I may be doing it in court. I have been doing it for the last 21 years. But as institution, we are not able to curtail the arguments. We are not able to put some restriction on number of pages thrown at the court. The reason is very competitive bar and lucrative legal court. But we need to do that. Because if a lawyer on a simple point cites some 25 decisions of a court, talking about a civil judge or district judge, he has to refer to all 25. So on a simple point, the judgment becomes very lengthy. Because then somebody will criticize him that lawyer had cited 25 judges. And technology has helped us a great deal, but the other side of it, I must tell you, there's one point, I'll tell you one point. Constructive res judicata, I'll put it this way. Now, on one particular aspect, there may be a direct judgment of the Supreme Court. But now, it is on fingertips. So what lawyer would do is, direct judgment of the Supreme Court, direct judgment of the parent High Court, not one, but several, and judgments on same points of all High Courts. So, on one aspect, on one issue, he will throw 25 judgments at the face of the judge. Now, we have to do something about it. We have to restrict the members of the bar when it comes to their arguments, the time they consume. Restriction has to be put. But at every level, it becomes very difficult. At Attalika places, district places, if some judge is strict, then we get those angry gestures by the bar associations. There are protests made against the judges if somebody is very strict. So ultimately, it must come from the bar associations. And ultimately, if they decide to curtail or to save the time of the court, because I always tell in judicial academics, every single minute is very precious. We work for 5 hours and 5.5 hours. Every single minute is very precious. We should not be wasting time on the court. But that initiative has to come from the members of the bar, and we as judges also, we have to be very firm and strict. I personally always believe, and I try to practice that we don't become judges to become popular. Ultimately, you have to deliver justice, and deliver justice a hard way. But this area is area of concern. You are right. And talking about the jurisdictions in the other court, I attended a workshop arranged by Medical Association. Very benevolent activities being conducted at one of the medical associations in Maharashtra. They conduct legal workshops 3 days in a year. They discuss various laws, not only medical negligence. So one of the very senior doctors asked me a question, that how come that in the topmost court in USA, there is no pendency, and you work only for 191 days. So I responded by saying only one thing, please find out how many working days the topmost court and Supreme Court works. They don't work for more than 69 days. And number of cases they deal with. Perhaps every bench in Supreme Court deals with so many cases in a month. So it's very difficult to compare the situation in our courts with the courts in foreign country. Because the situation is different, the litigation is different, the issues which members of the public face are different. So every court is different. But what we are raising is the correct issue and we must find answers to them.
Sir, I resisted asking that question, but now the legal literacy amongst the country citizens is rising. It is bound to convert into litigation, more litigation. Why are we still dependent for expansion of our infrastructure upon governments only? When we have independent budgeting and funds, we are supposed to remain independent of any power that be. 4 pillars. Judiciary should be the biggest pillar, main pillar. Why are we still dependent upon governments? Why can't we have our own separate funds so we can establish? We need 10 times more squads at trial level, 5 times more squads at high court level. Pendency of appointment of judges and consequence of staff is the major issue, and therefore there is more pressure on the judges who are already in the system. Why are we still dependent upon the government? That affects the independence of judiciary at the basic root. That is my prime question.
Firstly, a lighter way I'll put it, you must be asking this question to the governments. But I'll tell you something very important. Yes, today is the situation where, say, we want to acquire, say, 50 desktops, we have to submit a proposal to the government. And then government filters it and all that happens. But I'll tell you one more interesting thing. We as judges of the High Court, I'm talking about High Courts, it's a very tough job to handle administrative side. I'll give you an example. In the P Court phase 2, large amounts were given to the High Courts for acquisition of hardware, software. The value was in crores. Then we as judges of the High Court, we are required to conduct tender process. And it became so time consuming, dealing with tender process, dealing with objections, and ultimately our registry is also manned by judicial officers. So to maintain financial discipline is very, very tough for the judiciary. Because after all, we do all this work beyond the office hours. We sit till 8 o'clock, 9 o'clock, 9:30 in the evening, we hold our administrative meeting. So, perhaps for years, see, I'll put it differently. I will say that the government should be very liberal while sanctioning funds from the court. If that approach is adopted, perhaps all the issues will be resolved. And there are governments. I mean, yesterday's speech, Vice Chancellor referred. I refer to difficulties which I faced as judge of the Bombay High Court in getting funds from government of Maharashtra. But when I went to Karnataka, irrespective of partying power, Maharashtra also said irrespective of partying power, there is resistance. In Karnataka there was no resistance. So therefore the approach of the governments must undergo change. And I don't think if we are given those huge financial powers to spend money, to follow tender process, to maintain transparency, we are not capable of handling that. So in a sense, it is good that we are subjected to checks and balances when we deal with public money. Because we are not equipped to do that. We are short of time and resources to do that. But more practical solution to what you said is the approach of the governments must undergo change. They must realize that whenever judiciary submits a demand for the release of funds, normally without any objection that demand has to be released. That's the real answer to this problem.
You are ready to Lordships, I have one final question. The Lordship has served in Bombay, Bangalore and Delhi. out of these 3 cities, which one do you admire the most?
You candid answer to the question. Bombay, of course, I am born and brought up in a city very close to Bombay, so as a lawyer, as a student, I had opportunities to visit places. But in Bangalore and Delhi, my visits are confined to beautiful parks for morning walk and court complexes. It's very difficult to find time to see anything else. Of course, events like 26th August Republic Day Parade or that Amrut Udyan when it is opened. But it's very difficult to say which city is better. Every city has its own beauty. But I can say that in terms of weather, Bangalore was the best.
Thank you so much, sir. That was indeed an engaging discussion. And thank you, everyone. One more thing, it is now my honor to announce that among Amitsas, we have Mr. Yogesh Bhai Bhikavai Nyai, Sarpanch, Koba, Gandhinagar, and his wife, Mrs. Tejal Ben Yogesh Bhai Nyai, ex-VHIP GMC Gandhinagar, would like to constitute a gold medal for the subject of sociology on the name of his father, Mr. Yogesh Bhai Bhikavai Nyai, and additionally submit a check of ₹3 lakh to Gujarat National Law University. We'd like to invite Sir to the stage. Thank you so much, sir. Thank you so much, ma'am. Now, to conclude with this session, I must state before this August gathering that me, along with a lot of my classmates, spent enough time during this Delhi internship in Justice Oak's courtroom. We learned a lot, and it was once in a lifetime experience to learn from His Lordship. On that note, sir, it is an immense pleasure to have you here, and thank you so much for coming. I would now invite Dr. Nitin Malik, Registrar, Gujarat National Law University, to deliver the vote of thanks.
What a great day we had today, and we have amongst us the great visionary and the great personality, the Lordship Honorable Justice Abhay S, Judge Supreme Court of India. We welcome you, sir, and we are very indeed thankful to you and privileged to have you over here in this Gujarat National Law University. Honorable Justice Ilesh Vora, Judge Gujarat High Court, and our lightning force as an EC member as well as a GC member. We welcome you also, sir, over here, and we also are thankful to you for giving time over here to be present amongst us. As our dynamic leader and taking GNLU to heights, Professor Shanta Kumar, our Director of GNLU, Professor Girish, Brijesh Tiwari ji, yes, our own, I'll say the partners, because we are in Koba. This GNLU has been established in the village Koba. So we have the Sarpanch over here, the Madam Sarpanch over here. So the partners of GNLU, that is what is the extension of GNLU, what we say. Esteemed faculty, colleagues, and our invited guest over here, and yes, my dear students. Sir, it has been indeed, I was just, my Lordship will pardon me because so I was just thinking that what a topic you carried it out, contemporary challenges to the independence of judiciary, that too as a sitting judge of the apex court, the Supreme Court, and that is what you could say because when you reveal that for 20 long years you were an advocate and 21 years you had been a judge. So you have seen both the side of the coin, and that is why you could give us the 3 basic things which all students have to learn what sir had told today in the morning, today in this lecture. Number 1,
the quality. Number 2, criticism, but a constructive criticism. And number 3, privileged and proud that you are a student of National Law University. That is what we have to learn from a great personality the law students coming to us today. And that is what we say. Really, sir, you will pardon me again, I will take one more minute. I understand that you have to catch the flight also. But rightly said by sir, I too belong to the category of the students in 1980s when I was a student of Delhi University. So there also we felt that if you don't get admission anywhere, go to the law firm, the campus law firm, and where there is a lot of dignitary personalities. Rightly said, the legal education has been transformed in 90s only, and now Delhi University after late only realized that we also have to carry out a 5-year law program which was opened just last year itself in university also. So with this, I always say that the 3 words which we are going to take and learn from here today, all the students of GNLU, the quality, constructive criticism with reasoning, and 3rd, proud and privileged to be a member of the GNLU community, because you have to go out and outreach to the society to carry out further what you have learned over here. And that is why I always say to these young people who are the visionaries and they are the part to the Swarnim Bharat, परम को खोल जमाना उड़ान देखता है, जमीन पे बैठ के क्या आसमान देखता है, सोचेगा तभी तो उड़ेगा, ऊंचाइयों पे जा, तू है GNLU, तू जाएगा सोसाइटी पे और समाज की सेवा करेगा।
Thank you so much for such an inspiring session. Now to conclude this session, we would end with the national anthem of India. Thank you all for being a part of this special occasion. We now invite everyone to proceed to the preamble downstairs for a group photo. Our team will accordingly guide you. Thank you.